now's the time to think about it. Now, I will say that if in fact you do have claimants against you and you're saying, fine, I'm willing to fight those battles and to be prepared to pay those with funds that I'll set aside for that purpose, but I still want to form this trust and think about the future against claimants who are not here today. They don't exist right now, but I know they may. So I want to do my estate planning or my asset protection planning in view of those potential claimants down the road. You can do that, and most states will honor, and foreign jurisdictions will honor a trust that's been formed in which you have previously set aside funds for existing claims that are perceived to be adequate for that. And some people even do it within the context of the trust itself to make provision exceptions to the terms of the trust. In other words, they can have all that language that would provide the protections they need against claimants and yet say except for the following. And then they can list particular creditors that exist at the time that the trust is created. That's not uncommonly done. So don't misconstrue what I'm saying. I'm not suggesting that you have to be devoid of any claimants and have no lawsuits at the time that you go down this road of asset protection. I'm saying that anybody who exists at that time, you have to provide for them in one way or another. And you can do that outside the trust, or you can do it within the trust. So what I'm giving you an overview here is domestic and offshore asset protection trusts. But the self-settled trust problem has really been the sort of stumbling block to asset protection planning until recent times. And now we know that a number of states in the U.S. are pursuing this business for the same reasons, quite frankly, that the foreign jurisdictions pursue it, is that they recognize that this can mean a lot of money coming into their states. If you want to form a trust in a jurisdiction that's hospitable to self-settled trust in the United States, then they require that you form the trust in that state, that you house a certain amount of the assets in that state, that you have designated trustees in that state. In other words, they want the state to derive benefits from your housing the trust there. And it's good business. And among those, Delaware, of course, has long been a state that has had as aggressive asset protection laws as any. Alaska, South Dakota. There are a number of jurisdictions that have decided that they want to pursue this sort of business. The jury, quite frankly, is still out regarding how well these asset protection statutes in the various states are going to hold up. That one of the criticisms of domestic asset protection planning is that there's still some uncertainty. And here's what it relates to. One thing that has made the United States function effectively is that we've not been 50 independent states. I mean, the Civil War kind of settled the idea that we're not just a very loose configuration of countries, but in fact we're an integrated country with these state distinctions. And one way that they assure that commerce operates freely between the respective states is that each state is required by the Constitution to give full faith and credit to other states' laws. And this choice of laws issue and conflicts of laws, it's called, occupies tomes of materials in many classes in law schools because, as you might imagine, it comes up regularly. But there's pretty well settled law among the states saying that, look, if Alabama issues a judgment that's valid under Alabama law and they bring that judgment to Kentucky to enforce it against the debtor, then the state of Kentucky has to honor that. Now, they can require that the judgment be registered in that state, and they can require that certain fundamentals of due process have been honored by the state of Alabama. It couldn't have been arrived at with total disregard to constitutional rights of the debtor. But assuming these very relatively low-level requirements are met, then once that judgment is registered in the state of Kentucky, then Kentucky has to enforce it. It's called full faith and credit. So what we don't know yet about these jurisdictions, these domestic asset protection trusts, is will their laws stand up against challenges under full faith and credit? And an example would be, let's assume that someone in Alabama has gotten a judgment, a creditor gets a judgment against this debtor individually. It's issued by the courts of the state of Alabama. Let's assume Alabama is not one of these asset protection jurisdictions. Meanwhile, you have a debtor who's done everything that they need to do to have a valid asset protection trust in Alaska. So you have this creditor who takes their judgment that was issued by Alabama. They take it up to Alaska, and they say, I want to enforce this, and Alaska would not have recognized this self-settled trust. So under Alaska law, they've ruled that I'm to have this money because this trust isn't valid. Well, what happens? Can Alaska say, no, I'm sorry, but this is a case where Alaska jurisdiction is going to govern? There's a conflict of laws, and we think that in this conflict that Alaska prevails over Alabama. Well, the conflict of laws criteria will be settled ultimately in a federal court in that case.